Welcome to the November 30th, 2021 Zoning Board of Appeals meeting for the Town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I am now going to do a roll call. David Murch.
Tom Hennessy.
Greg Dean.
And it doesn't look like Patricia Beaton is currently here. We expect that she will be, perhaps later. This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you are unable to see or hear. The board works from a published agenda and will be considering tonight's items in the following order. Call to order. Number 2, approval of minutes from October 26, 2021 meeting. Number 3, old business, of which we have none. Number 4, new business, workshop with our town attorney regarding responsibilities and procedures for the Zoning Board of Appeal members. Number 5, code enforcement officer communications. And number 6, adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual rights to file any such appeal, you must be certain that the board's records evidence of your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to stand at the microphone to speak, to sign the speaker sheet, state their name, address, and affiliation with the application. All persons speaking shall address all remarks or questions to the chairman. This meeting is not over until the board has formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside the meeting room. So tonight's meeting is also being done via our remote participation policy. If Patricia joins, we will do roll call voting. So second order of business is approval of minutes of October 26, 2021 meeting. Did everybody get the updates that Sandy prepared last week for the date change?
I only got the paper copy that I think had the wrong year.
Yeah, I emailed the
Okay.
updated page.
I knew it was coming, I just took the paper copy came out.
Okay.
One,
So outside of that, is everybody pretty good?
Yep.
So still no Patricia? Okay, do I have a motion to approve the minutes?
Motion to approve the October 26 meetings, the minutes, sorry.
I'll go ahead and second that. All in favor of approving the minutes, raise your hand. That's it. Approved. No old business, so on to new business. Workshop with our town attorney, Phil Saucier, regarding responsibilities and procedures of the Zoning Board of Appeals members. That's us.
Thanks for having me.
Thank you.
Before I start, I know you've sent me some questions, and so I'll go over those.
He needs to go to the podium.
I should go to the podium.
Oh, wait a minute, I'm sorry.
Happy to go. That's,
Is your
think
green,
you
green
have-
light on?
I
Good.
think
The
that's
green light's
fine.
on.
Yeah,
Okay.
you're fine.
So I like to go over a few things. I'm not going to go over everything you need in a public officials training, but I think there's a few things just of general nature to touch upon.
Yeah, and I'll interrupt you just for a second. Sorry. All of us, we're on this board as of 1 year or less.
Okay.
So we're all new. Patricia was the only one who's would be considered a long timer.
Okay.
So we're all pretty new.
Good to know.
Yeah.
Yeah. And have you taken any other, like the Maine Municipal Association trainings or anything like that?
I've taken it.
Tom
You have.
has.
Okay. So you've got that sort of basic foundational, but the other two haven't.
Correct.
I'm going to go into just, so some of the things I'll talk about are very basic, apply to every board. I'm not going to spend a lot of time on those things, but they're good to know. And then I'll get into some of the specifics in your ordinance that you guys deal with. I would say that if you have access, and I know the town does now, to the MMA Board of Appeals manual, it's a very helpful thing, and you can probably get it from the town office, or there's a password for it. But I even have it on my desk. They cite almost every case that's come out in our area, and it's easy to read, and I find it to be just a good primer if you need something. So that's just some basic information I think it's good to have at your fingertips. So the first thing I'm going to start is very basic, which is I like to I call it a sort of refresher of sort of what it's, especially for those members just recently on a public board, sort of the standards of sort of behavior and expectations of public officials generally. Because particularly people who come from the private sector, it's a little different. There are different expectations. One of the things is the Freedom of Access Act, which you mentioned as part of your introduction, that applies to the work you do, but also just the sort of carrying out the town's mission as a public body. So the first responsibility you have sort of as a fiduciary to this town, and you're in this very specific role, and more specific than sort of the Board of Selectmen, for example, is to not let your personal feelings or priorities to get involved in your decision making. That your job here is to administer these ordinances that were passed in this town by the town meeting. Obviously, there can be different interpretations on what the words mean and things like that, but not your personal feelings about whether that's a good ordinance or not. That's a different issue, and if that you can change that through the town meeting process. But we do sometimes see board members who either don't like the ordinance provisions or they don't like a project, and they'll vote that way instead of applying the facts of that project to the ordinance. So that's a very important thing, because that's one of the easiest ways for someone to overturn your decision if they find that there was some sort of bias. And I'm going to get into specifically about conflict of interest and bias a little bit separately. It's also, I know you guys do this, but sometimes we don't nowadays, but I think decorum and civility go a long way in having a good board meeting. And that essentially means treating people with respect, allowing people to speak when it's appropriate for them to speak, and essentially to allow people to have that time. That also goes a long way sometimes in tamping down any appeals, if people feel like they've got their point across, even if it's you vote the other way. Board meetings are always public, as you know, under the Maine Freedom of Access Act. And that doesn't mean that there can be unlimited participation, though. So the participation only comes from when an applicant's turn to speak, or there's a public hearing portion of it, when the public can speak. But people do have the right to come and listen and hear. And the only time that's not true is in executive sessions, and I'll get into that again. I've already mentioned this. When it's apparent that a matter deserves more time, I always sort of think the deference should be made to give more time. It can be difficult and annoying, quite frankly, sometimes, if there's a really contentious project. But it's good to allow everyone to get their thoughts out. And there's a fair opportunity to be heard. The matters you decide, and this gets into where your questions, have to be acted on by a board and be based on evidence or presented in the record and not outside of the record and outside of the board. That is for a couple of reasons. It's considered a due process violation. I'll get into what that means technically. If we bring in information that the public and the applicant weren't privy to, because they didn't have a right to respond to it and understand it. And it's information that not everyone has the same access to. That doesn't mean you can't rely on personal knowledge. I mean, it's particularly in small towns, we drive by places all the time. You can't help but know what a lot looks like sometimes, or maybe your professional background gives you some insight into certain things. You can't unknow that. But that doesn't mean that you should be doing independent research on an application. You can bring your perspective to the board and say it out loud on why you think something, so everyone can hear where you're coming from. That independent investigation was actually one of the specific questions, so this might be a good time to sort of delve into that. Individual visits, the Maine Supreme Court, I'll call it the law court, which we call it for short. The law court has held that individual visits, investigations, sort of individual site visits are enough to overturn your decision. So even though as a board member you think you're just trying to be the best board member you can be and get the most information that you want, that you can have, the courts have said no, that's not appropriate. Again, it's the applicant's job to provide the information to see if they meet the standards and should be approved or denied. It's not your job to do that for them. And the public has an opportunity to also provide information to you. And that's the information you should be using, and not your own independent research. Again, because we can have the decision overturned. We've already talked about applying the law as written. Conflict of interest. This is an opportunity for me to talk about that now. Again, this is one of these basic things that are good to know. Maine has a municipal conflict of interest statute. And there are two ways that what we call per se conflicts of interest. In other words, if it comes before you, you must step down. There's not really a debate about it. And the first one, it's in statute. It's 30A MRSA 2605, is when you essentially are a part owner of something. Now, it's more specific than that, but that's a shorthand for you to think about it. So if there's an applicant that comes in front of you, and you are you own at least 10% of that company, that's what the statute says. So a minimum, if you have at least 10% of the corporation through stock or even indirectly, and you're an officer, director, partner, associate, or stockholder in that company, that 10% rule means that there's a per se conflict of interest in that, and you need to step down, otherwise the decision's voidable. It's not a debatable conflict. That statute also has says you need to avoid the appearance of a conflict. That's always a little more difficult, obviously. What is that, an appearance of a conflict? That may mean that you have 5%, right? Maybe you're a small owner, or you've got some sort of economic connection to that company. That doesn't necessarily mean there's a conflict, but what it means is you need to avoid the appearance by disclosing it, and then stating on the record, if this is true, that even though you've done business with this guy, or your cousin works for that company, so you have that connection, in your mind you can be impartial and proceed without bias in that application. So that's how you cure that issue. It's you disclose and you discuss, and then what should happen then is that the board actually votes to agree that you can stay on the board for that decision. That's the way that process works. If you don't do that, and someone raises the issue of conflict, that could be a way to attack the decision later on. But this is a way to address it ahead of time, and courts typically will defer to that if you've made an unhonest disclosure like that.
So a vote in that case, does it have to be unanimous or just by majority?
Just by majority, yeah. And it's rare that I've seen a board disagree with the members when they're sort of voluntarily, because some of this stuff obviously is voluntary. You sort of have to. People don't know you may have a potential conflict. It's up to you to disclose that and think about it for yourself. The other potential conflicts, again, they're sort of in our own heads, and it's an appearance of conflict that can be an actual conflict, or what we call predisposition or bias. I got into that when I first started. So if you already have predisposed against or for a project, just for the nature of it itself, not that you think it meets the standards or not, or you have a bias against someone or a project, then that's a reason you should probably think to yourself, you shouldn't be sitting on this particular application. If you think you can't apply the facts of the application to the ordinance in a unbiased way, then you should think to yourself about whether you should be on it, because that could be a potential way to overturn the decision. If you do, and again, this is the appearance issue, if someone may in the community think you could have appearance, because maybe again you're friendly with somebody, or maybe you dislike somebody even, but you think that you can look at that application fairly, then just disclose it. I know Bob, we've been doing stuff together for a long time. I can look at this application with no predisposition or prejudice or bias, and so I think I can sit on the board. That's how you cure it. The only other, is what we call de facto conflict. So there's the 10% ownership is a de facto conflict, and the other one is familial bias. That's if one of your family members is applying for something. And that's defined in a very specific way. It uses the Wills Trust and Estates word of consanguinity, which I learned 20 years ago now, but I barely ever use anymore. What that means is 6th degree of consanguinity, but the short way of thinking of it is second cousins and closer. So that means your second cousin or closer to you, then that's what we call familial bias, and you should not be hearing that application. And again, the failure to abstain when there is a conflict, or someone can argue there's a conflict, it means that the decision is voidable in the future on appeal.
Okay,
Any questions about conflicts? Yeah.
Yeah. So let's just say, can there be a situation where you can listen, voice your opinion, but then not vote? Like that, like, I don't want to necessarily step out of the whole thing, but you want to be able to, just let's say a neighbor is coming in and doing something that's like, I don't feel like I'm biased, but I may want to just contribute to the discussion, but choose not to vote so as not to appear like I'm biased because they're my neighbor.
It's a good question, but you really should participate or not participate. There should be a middle ground. So if you think you really can, you're not biased, even though there's that perception, just disclose that early on and say, they're my neighbor, but I have no opinion about this. I think I can sit here in an unbiased way. Everyone, you make that. Sometimes boards will even, and depending on the issue, you even ask the applicant if they have any comment on that. In other words, if they really are opposed, but it's got to be for a reason for bias. It's not, you can't, don't just step down because people, they don't want your vote and they think you might be a vote against it, right? That's not a reason to step down or for someone to try to get you knocked out. It's if there really is one of those conflicts I just went through.
So is there technically a difference between recusing and abstaining? Recuse, basically you got to go back out and sit in the audience
Yes.
and say nothing?
Yes,
Okay.
that's right. Yeah, so if you are recused, if you step aside because of a conflict, then you can stay in the room, but you should step out from the table, from the dais at the table.
Could you participate as a public participant?
You can,
Okay.
and that gets into touchy areas, and people don't always like it. But in a relatively recent case in Wiscasset, the Maine Supreme Court said that people have the right to still participate as citizens. It just had to be very clear that you are not a board member, you've recused yourself, you've physically stepped down, and that maybe, but you have some sort of interest that you want to do. I mean, I think it's a rare case. In that case in Wiscasset, the issue was, it was an applicant, quite frankly. It was an applicant, like, it was someone who was on the board needed approval for something. And I want to say even his engineer was on the board. So I think there were two connections, but he needed an approval for something, and he was a resident of town.
Yeah.
And so they stepped down, applied, and one of the arguments about someone who didn't like the project was that was some sort of bias. And the court said, no, people have the right to still participate by applying for approvals or voicing opinions, but there's a fine line. You have to make it clear what role you're sitting in. Mm-hmm. And I wouldn't do it just lightly. I would do, I wouldn't do that all the time, if just because you have an opinion about a project, right? Because you are, first, you're a board member, and you should try to sit as a board member if you can do that without bias, and not step down from your duties, essentially. Unless you feel like you absolutely have to, and there is a conflict, you can't be unbiased moving forward.
I got a question as well. Like when we earlier talked about the lot visits.
Yes.
Like we'll do the site walks
Yeah.
together as a group. It was my understanding that if a board member was unable to make a site walk, they could at least, if it's on a public roadway, they could drive past it, not stop and get out and take pictures and observe, but at least drive past it just to get an idea of what
What it is.
Yeah,
So that's a really good question. So what the courts have said is site visits should be done as a body, meaning when you actually get out, walk around, and things like that. They've got to be noticed. People are allowed to come and watch if they want to. They can show up. It's a public meeting, just like this is. You shouldn't be asking a lot of substantive questions. You can ask, you're supposed to, it's really a visit to just sort of get in a sense of where the thing might be, what the lot looks like, that kind of thing, but not start getting into the merits of the application on the site. You shouldn't be doing that. So people shouldn't be walking around and doing site visits on their own if it's out of that context. If someone, I mean, again, we live in small towns, if you're just driving by and you got a sense of it, the way you shouldn't be doing that on a regular basis, but if you do that, you just disclose it at the meeting. So that's always the way, to the extent that anyone has information that other people might not have or they didn't know you do, you just say it. So I had an opportunity the other day, I was driving by, I just wanted to, I did drive by, so I did see the lot. That's the way to kind of cure that issue.
Okay.
Again, that's not every day you want to do that, but if you do, that's just what you do.
Okay.
This gets into my second general area, which is Maine Freedom of Access Act, and so it's actually a lot of what we talk about is actually part of the Maine Freedom of Access Act. Site visits are actually sort of wrapped up in that too. The very basic way to think about Maine's Freedom of Access Act is anything we do in the public is for the conduct of the people's business, is that it needs to be in the open. That's the general concept. And that it's divided into two separate categories: meetings and documents. So a lot is sort of broken up that way. So on the document side, everything that you're given as part of your job as a board member, for the most part, is a public document. Everything you write as part of your job is a public document. So think of it that way if you're feeling tempted to write something. That anyone could ask for a copy of that through the town office. We call it a forward request or an access request. I want to see copies of everything the board members had on this particular date, and you have to hand that over. There are some exceptions, but you start with that premise. You start with the premise that everything related to public business is public, and people can ask for a copy of it. The exceptions are certain financial information that the town might have, social security numbers, some things that are obvious that they can black out or not hand over, certain employment records, for example. There's a long list of them in statute. Certain police records, there's all kind of there's a whole statutory. The one that really applies to you is there actually is a specific one on disability variances. I'm going to get into the type of variances later, but that was added by the legislature a few years ago. That in Bremen, the code officer has the authority to do a disability variance. But in some towns, the zoning board has the authority to do that. And that's one thing that I can think of that applies specifically to boards of appeals. If someone's asking for a disability variance and they have to hand over the proof that they need it because they have a medical condition, that those medical documents are not public. What I typically think, I mean, you've probably heard this before, but it's good advice. Don't write anything you don't want on the front page of the paper, because it probably will get there someday if it's that inflammatory and there's someone who's, especially if it's an issue that people care about, they're going to ask for it, they're going to see it. So think about that when you're in your role as a public member. I just tend to write very little when I was in a public, you shouldn't really be talking on email much anyway, but certainly not in your personal, to your friends or your family about the work you're doing here. Just leave it alone. You're not supposed to do it anyway, but it's also you're creating a public document that can be obtained later. So think of it that way. On the meeting side, again, we start with the premise that everything we do is public, just like tonight. Anyone can walk in this room tonight and be here if they want to be present. I mentioned they don't always have the right to speak. There's rules about when people speak. We have to be able to run a meeting, but they have the right to watch and be here. There are certain meeting notice requirements, which Raymond is usually taken care of for you by staff. But ample amount of time. It's pretty basic. It's less than people think. You got to post an ample amount of time for people to get here, with sufficient sort of notice about where people and how people can participate. There's certain local requirements that will add other things like number of days or needs to be in the newspaper or not in the newspaper, things like that. But generally, you need to let people know how they can participate, and then you need to make a record of your meetings. We usually do that through minutes. Minutes themselves are not required by law, but it's a record of the meeting, which has, at a minimum, has to be the date, time, and place, the members that attended, and the motions and votes taken. That's all you actually technically need under FOA. And now audio and video satisfies that requirement. So in fact, if it's being taped, you wouldn't actually have to technically write anything. Although minutes are still a good idea because it's a good shorthand. People don't want to have to go back and listen through a whole meeting if you really just need to know what happened that night. So it's still a good idea to have it written in my view. Again, just like on the record side, the document side, there are exceptions. We call those executive sessions for meetings. Very rare that a board of appeals or a planning board uses executive sessions. They're more typically used by city councils and boards of selectmen. Because you have to fit within the exception, just like on the record side. So there's like 7 or 8 reasons you can go in executive session. One is the disposition of property, because it would put you at a disadvantage if the town's trying to buy or sell property. You can talk about that in executive session. Labor contract discussions, certain employment matters, discipline matters, and things like that. School boards have a couple specific ones, like student suspensions or expulsions. And then the one that I'm brought in the most is consultations with legal counsel regarding the legal rights and responsibilities of the board. And to trigger that, you have to actually have your lawyer present. Some boards try to talk about legal issues without their lawyer, but you lose. There is no attorney-client privilege in that case, and so it's not real. But I can zoom in and I can call in, which makes it more cost-effective if they need to do that. But I have to be present for them to trigger trigger that. That is where you sometimes see a zoning board or a planning board every once in a while have an executive session. If, for example, if there was a case that you had that was appealed and the court, this is one of the few times we'll see it, the court remands it back to you for further work. It's sometimes helpful to have an executive session so you understand what the court did and any kind of legal advice your attorney might need to tell you beforehand, before coming back in the public. But it's pretty rare. So just think about everything you do who's going to be in the public. And the final thing I'll say about that, again, it's because you don't do it very much, is that you can't ever vote in executive session. However, it's only a place to discuss. All votes have to be taken in the public. Again, the idea meaning the public has the right to know what the board is doing. So sometimes you'll see boards, they discuss something and they had a vigorous discussion, they come out executive session and they just vote with no discussion. So you don't always get a lot out of it, partly because it's probably confidential what they are doing, but they actually voted in public. And that's why. So some of the issues under FO, we talked about one of them, which is site visits and things like that. That's still a meeting. Where the other places you see it is just the idea of a meeting in general. We typically, some lawyers disagree and have a more strict view, but I know MMA and our firm believes that it's 3 or more members of a board discussing town business is a meeting. 3 or more people, talking about the Red Sox is not. Some people might think you are, and you'll see that sometimes in the paper. You'll see some of that. We saw the 5 members of the planning board down at the pizza hall sitting together, and they're, and they've got conspiracy theories about what was happening. You can do that. You just can't talk about business. Once you start talking about the business before the board, then it's a quote meeting under the Freedom of Access Act, and that would be an illegal meeting because it wasn't noticed and the public weren't able to come and be participating in it. Again, the idea behind that is the public has the right to know how you're arriving at your decisions. It's got to all be sort of in the public.
Just to clarify,
Yeah.
so 2 people of the board could meet, discuss the issues that the board is, tasked to deal with, and that's okay, but 3,
Yeah,
it seems like there's a transitivity issue there.
Yeah, so it's a little bit different in your case. What I would say is, there's sort of 2 different things that boards do, and one is sort of policy decisions, and the other is what we call quasi-judicial decisions. In other words, you're acting on an application. That's what you do. And in my view, I say you should never be talking about it, whether it's a quote-unquote meeting or not.
Right.
You should be talking about the application only in this room, right, in the public. That's a good point. I want to clarify that. Being on a town council or board of selectmen is a little different because they're not always, their agenda is not always filled with applications for permits, for example. They do have some of that role, liquor licenses, and there's a couple other things that they sit in a quasi-judicial capacity, but generally they're policymakers. Whether to move forward, particularly on, whether to move forward with an ordinance amendment, whether to put together a policy on remote meetings. There's all kinds of things like that. And counselors frequently do talk to each other, or select board members frequently do talk to each other one-on-one about things like that. But the same rule applies to them if there's an application in front of them. They're not supposed to be discussing applications. There is a difference there.
What about procedural questions often, like it just came up earlier about tabling, how long something can be tabled for, do we need to address it, what the attendance is going to be, things like that. Is that considered a meeting? Kind of a meta meeting?
It's some exceptions. So quorum purposes, for example, the FOA, there's an office called the FOA Ombudsman at the Attorney General's office. It's a woman's currently filled by a woman named Brenda Keelty. She's been there for a little while now. And if you go on her website, she actually has a bunch of FAQs. Her job is to be the sounding board for FOA questions from both the public or agencies, for that matter, public for the agencies. She's an assistant attorney general, and it was created a number of years ago, that position. And some of the guidance that came out of that office suggested that discussions about quorum is not substantive. Just are we going to have enough people there tonight? That kind of question on an email, for example.
Right, is December meeting happening?
Exactly.
Like that.
Those kind of things like that are completely non-substantive.
Okay.
There's a little bit of danger area where you went into, but the application of rules, procedural rules, you should defer that to the discussion, like the interpretation of rules.
I see.
For example, because there could be different opinions and stuff like that, and then you do start getting into a debate. You should not have debates essentially on email or outside of the room. So those are some of the common sort of violations that are polling by members before a meeting by telephone, or or discussing the application in the grocery store,
Right.
things like that. The other thing you see a lot now with social media is people discussing sometimes on Facebook or Twitter, things like that. I'd say that's pretty rare. It happens every once in a while. But that's maybe not a meeting per se, but it's just a violation, due process violation you shouldn't be discussing. And at that point, if you've had any public comments about an application that's going to be coming for you should probably step down. You're getting into the level of sort of potential conflict of interest there.
Right.
Because you're discussing the substantive matters outside of the meeting. That's all I feel like I need to really go into FOA, but I wanted to make sure that everyone understood the obligations we have under FOA. Violations, if it's a willful violation, you can have a penalty against you personally. It's rare because it's going to be willful, but in theory it could happen. What would typically happen, though, if there's some sort of violation, because it's not usually willful, it's people didn't really understand what they're doing, or is that you could have your decision overturned. It would be part of an appeal that there was a FOA violation as part of it. You were discussing something out of the meeting, for example. I think that actually got into all three of Dave's emails to you. I'll just read to you your questions so people knew what you sent to me. What level of research can the ZBA do in advance of a meeting? That was one of your questions. I touched upon that, but this gets, while we're in this area, again, you really shouldn't be doing any. You can look at the ordinances, you can look at the application, you can look at the information that's essentially packaged for you as the application. That's what I would say. Really don't go digging around. Again, you could probably learn a lot, you could probably get, but it's not your job to do that, and it's potential due process violation, because again, you're having information that the applicant might not understand that you have, and so it's an unfair disadvantage for that person. You could be incorrect, for example, relying on information just not correct, and they didn't have the opportunity to try to persuade you otherwise without knowing what you've looked at. So everyone's supposed to be looking at the same information. That's the idea behind that prohibition.
And that includes like maps, like if you were to look at Google Maps or something like that.
Yeah, I think typically that should be an application anyway. But I think a map, that's sort of public information. I don't have as much heartburn over a map.
Okay.
But if you do stuff like that, just say that you've looked at it on a map. So that's always my answer, which is like, to the extent you've done some of the stuff that you probably shouldn't be doing, disclose it. Because then people have an opportunity to know what is inside your brain on this application, right? Like what you've looked at.
Mm-hmm. What about other public?
Looking at a map to me seems very minor and really very little that could be biased. Any bias for that. That is a map is what it is.
And there's tax maps and there's Google Maps and there's
Right.
whatever.
One way to deal with that is if you're looking for more information like that, specifics like that, is that you can ask staff for additional, you can ask staff to provide certain things like that for you. Not research per se, but some like information the town may already have. Tax maps, like you said.
Like who actually owns a piece of property.
Right. Well, for example, you have to, this is off topic a little bit, but someone always has to have right title and interest to be able to apply in your case. And to the extent you have some questions about that, the town will have that information in their assessing database. So that's an example you could ask the town to verify.
I think I want to say it right, MMA, is that what it was?
Yeah,
they've got
Maine
that-
Municipal Association. Yeah.
Yeah, and I'm pretty sure Sandy earlier on gave us an electronic copy of it. It was pretty thick.
It's
had
pretty
a lot
thick.
of case stuff in it.
Yep.
I'm assuming that's something we could research if we wanted to. Yes or no? So at some
You can
point-
have that. Yep. That I consider to be just a guidelines for the operation of your as a board member. It's not about the specific application, for example. That's the prohibition. It's the getting into the weeds and the research on someone's application.
All right. So what if, at some point, I know we're going to get something about the 4 hardship criteria.
Yeah.
That manual has a lot of information for board members to consider when it comes to that. I'm assuming it's valid for us to review all of that information.
Absolutely.
Okay.
And anything, sometimes I'm asked to provide a letter to shed some
Yeah.
light. Yeah, when I'm talking about research, I'm not talking about your ordinance or maybe interpretations of your ordinance. I'm talking about, because this has actually happened, someone who's an engineer goes into their engineering books and starts saying, well, I wouldn't do it this way, I would do it this way because you use this material. This happens a lot on the planning boards. That's what I'm talking about, research.
He should be on code enforcement.
Right, exactly. You know, like second guessing their own, the applicant's experts and stuff like that with your own research, not just based on your own knowledge again. That's what I'm talking about, not your ordinances themselves. And then finally, you asked me, Dave, when communicating with the code enforcement office while not in a public meeting, like emails, sidewalks, for several, what can and cannot be discussed? To what level do other board members need to be aware of these communications? So again, you should never be debating the merits or talking about the merits of an application. But what you can ask the code officer is for additional information that is appropriate for him to provide. So information about the ordinance, for example, the criteria that you need to apply, things like that. Ideally, that should be shared with, it should, not just ideally, that should be shared with everyone on the board to the extent you've got certain information.
So my request
Yeah.
should be shared, or Alex's response should be shared?
I would say both.
Okay.
Yeah, I would say both. Sometimes a board member will ask a staff member something just by themselves, but typically the staff knows that when they send it out, they send it to everybody, or or even sometimes included in the packet that goes out.
What about an administrative appeal? Same rule apply?
Yeah, and those are difficult because they're reviewing your decision. And so sometimes when it's really tricky, sometimes you're sitting independent of Alex in those situations, obviously.
Have you guys done an administrative appeal? You haven't, yeah.
Yeah, I'm about to.
Not in our short brain here.
Yeah, so it's gonna be tough for you to kind of.
It's a tough one. Why don't we wait just 1 second on
Yeah.
that? Because I'm actually now turning to your specific
Yeah.
sort of rule responsibilities here. Now that we've gone over sort of a bunch of the basic responsibilities you have. So I like to start from the top when I talk about Board of Appeals. I also sat on a Board of Appeals for 7 years, so I sat on your side of the table as well. Some of these things especially variances, are very difficult to apply, and there's no doubt about it. But the first place we look to determine what is the jurisdiction of a Board of Appeals is first we look at, there is a state law statute, a Board of Appeals statute. That's the statute that authorizes, in effect, requires towns to have boards of appeals if they have a zoning ordinance. It's one of the prerequisites. If you have a zoning ordinance, you have to have a Board of Appeals. And the statute lists certain powers that you can interpret the provisions of an ordinance into question. You can approve special exception permits or conditional uses, although sometimes planning boards can also be given that responsibility. And then you can grant variances that are in strict compliance with the statute. And that statute outlines a number of variances, and it's very specific on those. That's what the variances have to look like. There are mandatory variances and there are optional variances. You have one of each. So the mandatory variance is what we call the undue hardship variance. Every Board of Appeals has that variance in the state. There are the only other non-optional mandatory is a disability variance, which I don't believe is actually technically in your ordinance right now.
You do have one.
You have the one that's
You
the
have
code
an
officer.
ADA, yeah.
And that's okay because the legislature a few years ago said that you can give that authority to the code officer if you want to. There's another sort of optional disability variance which allows boards of appeals to grant disability variances essentially for carports. So covering cars for people who need it covered to get to their house. That's optional though, it's not required. The only thing that's required is the ramps and accessibility variances. All the other variances are what we call optional variances, which means you have to decide as a town whether you want to put them in your ordinances. One's called a practical difficulty variance. I'm not going to get into that much because Raymond has not adopted that. It's essentially, for lack of a better way of saying it, a slightly easier variance than the undue hardship variance. It's still very difficult, but it's slightly easier to be able to meet those standards. There's the setback reduction for single-family homes, which you have adopted. And you've got to follow the statute specifically, and you do. I think that's all. That's it. So the only one you really haven't adopted is the disability variance for especially carports and the practical difficulty. So first, that's what it says. So then you look to your own ordinances, and your ordinances essentially mirror that state law. The first one is the administrative appeals. That's what Alex just mentioned. That's what your first sort of jurisdictional responsibility. And that is that anyone can appeal a decision of the code officer to you. So orders, determinations, interpretations he may make even. So how he interprets an ordinance, he can appeal that. They can appeal that to you. And then you're sitting reviewing his work in what we call a de novo basis. I want to say your ordinance actually specifically says that, which is helpful, which is good. There are two ways, and I'm not going to get into this a lot because you only have one of them, but there are two ways of deciding appeals under Maine law. One is de novo, which means you're deciding afresh as if the original determination never been made. So you're now sitting in Alex's shoes as if Alex didn't make his determination. That's the way you review his decisions. There's another standard called an appellate basis, which is a more deferential review. And that isn't sitting afresh. You're just determining whether the original decision maker's decision was supported by substantial evidence in the record. You could have come to a different conclusion, for example, but it was supported by the evidence in the record, and so it will stand. That's actually the standard the Superior Court will apply to decisions you make. The courts apply that deferential standard when they're reviewing municipal boards. It's called an appellate standard. But luckily, you have de novo, and I say luckily because we have a case from the Maine Supreme Court just a few months ago where they came out for the first time and said, we really strongly recommend that appeals from code officers to zoning boards of appeals are on a de novo basis. They rarely recommend policy, but they've had too many cases that have come up without sufficient findings from code officers, and they even sort of take pains of saying it's not really the code officer's fault. It's just not their job usually to write out long findings, for example. They're certainly not set up to have adjudicatory proceedings to allow people to comment like you are as a board. Oftentimes there's no notice required, for example, for a building permit. So people don't even know about it, unlike your meetings. So they said in terms of reviews from code officers, we really recommend their de novo. And that way, that means that your decision will be the one reviewed by the court, not Alex's. So that's the first type of, first job you have. Sort of now getting into where Alex was going with it, that does create a different dynamic because you're now you're viewing Alex's decision. You can still use Alex to provide information to you on how he came up with his decision and things like that, but you shouldn't really, again, just like any application, you shouldn't be debating the merits of it. And the way those proceedings go forward, since you haven't had one, is that usually there's someone actually appealing. So that person usually goes first and makes their case on why Alex was incorrect, whether it's in a butter withstanding or the permit or the person who applied for it who was denied. But they go first, they make their case, they're the one who brought the appeal. Then usually the code officer actually gets a turn, and they go next to say sort of why they made a decision. It's less important in de novo appeal, quite frankly, because you're deciding it afresh, but I've still always taken the position that it's still important to understand where the code officer is coming from, what information they were using. They have the right to provide the information like anyone else. And then you hear from the public, and then you deliberate. The second jurisdictional area you have are variances. This is the meat of it, I think.
Can I check you back? So Alex had said, just based on the way things are going now, there's a chance for some administrative appeals towards the beginning of the year. Now, we've also just hired Chris, the town has hired Chris Hansen. So, and he has been code enforcement officer in the past.
Right.
To what degree can we use him? Like, I mean, it may not make sense for us to ask Alex certain things, but maybe it would make sense for us to ask Chris, since he is. But would Chris be considered biased in this case?
I mean, to the extent Chris has been involved, he's essentially the same person for the approval. But you can ask them anything you want. You shouldn't be doing much behind the scenes anyway. So I think of it as a very rare occasion you'd be asking questions anyway. You can ask in public anything you'd like, right? Like in terms that's relevant to the application. And there's no prohibition on you doing that, even though you're reviewing his decision. To be able to come to a decision on your own, whatever you need to be able to come to that decision.
So today, if there's a code violation,
Yeah.
is Alex signing paperwork or is Chris? I mean, I don't
Well,
know
we
how
both
it works. but-
depends. So the workload is basically split between the two. So Chris does sign off on permits. Chris does send NOVs. He sent one since he's gotten back. So there could be a possibility where you could have someone appeal one of his NOVs or one of his
Okay, so
denied permits.
Either one of you has signing authority or whatever.
Yep.
the right
Mhm.
word
Yep.
is. Okay.
Right.
Yeah,
Yeah.
it's not set up so that everything comes through me, for
Right.
example.
Yep.
Yeah.
Is there, maybe unrelated to your talk track, but curious, will Chris ever appear here as well in lieu of you, or is it, seems like at least consistently it's been you?
His role as the assistant did not include any night meetings
Got it.
unless it's specifically involving him. Like he's had to go to a select board meeting for a project he was working on, and if one of his permits got appealed or a notice of violation got appealed, he would come to that
I see.
meeting.
Okay.
Yeah, we would probably both be here for that one.
Got it.
Sometimes, and it's rare, I'll just mention it because I've had to do it somewhat frequently recently, sometimes you'll have, depending on the issue, you may have an attorney represent either the code officer or the board or both. And that happens sometimes. So you may see that. And typically that will happen if it's a fairly contentious issue and it looks like it's going to court after your decision. That's when I usually step in and represent the town and your decisions in front of the Maine Superior Court and Supreme Court. But sometimes we're brought in before that because we sort of know it looks like it's going that direction and to provide guidance and to help with findings of fact, for example, and things like that. So when that happens, the municipal attorney has to make it very clear which side of the table they're sitting on. And that depends on the town. It depends on the issue and the town's decision. Sometimes, I'll just give you an example. I did this is one town, the town was the applicant themselves. They had a new library that needed to go to the planning board. And they got an approval and a neighbor appealed it to the zoning board. In that case, the planning board's decisions went to the zoning board. It doesn't happen here, and I'll get into that in a second, but that can happen. And so that was an important project for that town. And so they wanted me to help the code officer, to essentially represent the code officer before the Board of Appeals to make sure that their permit was sort of upheld. And again, because it was so contentious, the town also hired a lawyer for the zoning board. So that happens. You have two lawyers being paid by the town, but with different roles, just like you guys have different roles. That does happen from time to time. And sometimes you have the town's attorney just sit on one side and they say, you know what, either the board or the code officer can take care of themselves. You see that sometimes too. They'll be fine by themselves, but we do want, usually it's the board if there's a case, and I haven't been involved. So Alex and I'll have that conversation sometimes, or code officers. Sometimes I'm involved in their decisions, meaning that they've consulted with me, I've given my opinion on something, I'm very aware of, maybe even reviewed the notice of violation. If I've had any kind of substantive involvement and then that notice of violation, for example, is appealed, then I usually say I cannot help the Board of Appeals because I don't want to create a conflict situation for the town. That could be potentially seen as a conflict. I'd be essentially advising you on what I already signed off on, essentially, or agreed with. So then that's when you'll see outside counsel come in just for a single case, for example. There are I do it for other towns too, where I'm not the town attorney, but every once in a while I'm asked to come in for a single matter, to step in for somebody. So you will also sometimes see that, just to make you aware of that.
How about a situation where, let's just say it's an administrative appeal and there's a town attorney that sort of represents both Alex and as an advisor to the board with that typically?
That's what I'm getting at. Yeah, so the town attorney shouldn't be doing that.
Okay.
To the extent that they've advised the code officer and the code officer's decisions being appealed, typically, not always, because you can make a determination that you weren't really involved. You may have answered a question that was sort of general in nature, but if you were involved in sort of the decision, then you would not be then usually representing both entities.
Okay, but let's just say you had no involvement at all
Yeah.
prior to this, and then there was some sort of appeal that occurred to
Yeah.
which it's advisable to have somebody to talk to Alex as well as talk to the board. Is that Was that legitimate to have one attorney for sort of?
No,
Okay.
no, yeah, so that's when, if you really do need it for both parties,
Okay.
the town will hire 2 attorneys. I usually stay on one or the other side,
Got it.
and then we'll get someone else so that there's independent advice happening.
Perfect.
Yep, and that's pretty rare, but it does, it does happen. So that gets us into variances. That's your next big bucket of work. And variances are notoriously difficult. They're difficult on purpose, even though it can be very frustrating to both applicants sometimes and board members. But the reason for that is that there's a presumption under Maine law, both in the statutes and courts, that we want to eliminate nonconformities. That's the presumption of every zoning ordinance, is to eliminate nonconformities over time and create more conformity with the rules of the zoning ordinance. And a variance is specifically allowing someone to do something that's not in your zoning ordinance. So as a result, that's why it's difficult to achieve. However, it's an important thing because, as you've seen probably already, there are certain times when the zoning ordinance just doesn't make a lot of sense for that particular property. And what I usually say, it's an important pressure relief valve for our ordinances. You need to have some pressure relief valve, because there are going to be certain circumstances where the rules just should not fit. And we determine if it shouldn't fit if they meet the criteria.
Yeah, I'll just interrupt you just
Yeah.
for a second. We have not had a variance request.
Okay.
The 3 of us, in terms of the undue hardship. We've only done
Setbacks
through
and-
setback reductions.
Okay.
Yeah, so,
Well, good. Okay, well, we're going to look at it from scratch then.
I think there was one back earlier that he checked off variance.
yeah.
Then it changed to
we
be a,
changed, yeah, we changed it. Yeah,
Setback.
you're right, we started
I
off
think
down
it
the
started
variance
off that
road.
way, but.
Yeah.
Yep.
Yep.
So there are 4 criteria. And it's that the land, and I'm going to read them. So undue hardship variance means, first, that the land in question cannot yield a reasonable return unless a variance is granted. I'm going to go back over each of these. 2, that the need for a variance is due to the unique circumstances of the property and not to the general conditions in the neighborhood. 3, that the granting of a variance will not alter the essential character of the locality. And 4, that the hardship is not the result of an action taken by the applicant or prior owner. And yes, I've got your ordinance here. Variances in this town, and this is pretty standard, is the ordinance, the statute says you can limit what variances can be granted for, and it is limited here. You can't get a variance for use. So if, for example, commercial is not allowed in a district, you can't ask for a variance to allow commercial use. But you can ask for dimensional variations from the dimensional standards. So height, area, size of structures, yards, and open spaces. That's what your ordinance defines as what's allowed to be for a variance. The most difficult one to get over, the most difficult hurdle, is the first one, that land in question cannot yield a reasonable result. Reasonable return. Unless a variance is granted. And so the first question is, well, what does reasonable return on a property mean? If, for example, someone needs a variance in their view to be able to construct a single-family house. A single-family house wouldn't fit on a lot without a variance. Side setback, for example, maybe. Well, what the law court has said is that an applicant needs to show that the denial of a variance will result in the practical loss of all beneficial use of the land, and only should be granted if the property subject to the regulation cannot yield a reasonable return from any of the permitted uses in that district. So in other words, it's not that they can't build a single-family house. They don't have the right to build a single-family house unless they comply with the ordinance. There's other things they could potentially do. And I know I had a question about a case nearby here called Toomey versus the Town of Fry Island. And that's an interesting case because what the court said, for example, and it's consistent with courts around the country, because most of these come from enabling acts that happened in the 60s or 70s, and you see some of this language in other states. But in that case, a gentleman was asking for a variance on Fry Island. on the water, a lot along the water for a variance to allow him to build a single-family house, needed a variance to be able to do that. The board denied the variance due to the unreasonable return standard, and the law court upheld that denial. And the reason why is because in that case, the board found, and the law court found was reasonable, that he had the ability to use the lot to dock his boat. That was something. And that was a reasonable return. He couldn't build a house, but he could dock a boat. In other cases, you've seen things like recreational tenting, things like that. It's essentially, it's again, what the court said is the practical loss of all beneficial use of the land from any permitted use.
Sounds like it might be beneficial to get a few examples of something that does meet that requirement. Because like if tenting, for instance, is reasonable return, that maybe you could elaborate on in a case that.
So there's one case in Scarborough which came after Toomey, and they cited Toomey, where the Scarborough zoning board upheld a variance for that same standard, where it was in a neighborhood where camping wasn't allowed. Right, it actually was not allowed there. And so there was nothing they could do, and it was in a wetland, so you couldn't bring a boat up to it. There was a setback from a wetland is what they were asking for relief from. So you couldn't bring a boat up to the wetland the way the wetland was in the marshes in Scarborough. And so that was an example where it met the standard. If it's again, it's easier to show that someone doesn't meet it if it's a waterfront lot, because you can use it for recreational purposes like that. But there's a lot of little lots that have, for example, maybe road access issues, and there's nothing you could use it for if you didn't get a variance for the
like
length. That
trapping, for instance, or something like that.
Yeah, exactly.
That's reasonable return. Right.
So potentially. It depends on the circumstances and what they're going to argue to you.
Is there a well-defined place of what, is there like a definition of reasonable return that we can use to help guide?
So the closest definition we have is what I just read to you.
Okay, so not really.
Yeah. And that's what we look to as lawyers too, is that we look to the courts to define it for us, and that's how the courts certainly currently defined it.
Okay.
I'll read you two. So there's sort of two provisions actually. That denial of a variance will result in the practical, I'm quoting this as a quote, practical loss of all beneficial use of the land, and only should be granted if the property subject to the regulation cannot yield a reasonable return from any permitted use. So and this would be in that manual, again, if you want to refer back to it. Yeah.
I apologize to interrupt.
No, go ahead.
The reasonable use, let's just say I don't do water recreation.
Right.
However, the property could be used for water recreation. So even though it's not something that's applicable to me, because I don't intend to do water recreation, even though I could still bring a boat there, means it's still, there's value to the property.
Potentially, yeah.
Okay.
If it really can be used that way. I mean, it does depend on the facts of the situation. That's the thing, is there are, that lot in Fry Island, for example, might be different from a completely other lot, right, where you may not be able to get to a boat, or it's not as practical to use a boat there.
Yeah.
And so to use that specific example, not every waterfront lot, for example, is going to have boat access as the reason why it's valuable.
Sure.
So it's going to depend on how the applicant explains it to you, what you think of their appeal.
I want to say too, when we have waterfront stuff, well, LLR, L1 and 2, we have to send them, I think it's to the Maine DEP, is that what it is? And they reply back. And I remember within the past year, there was like a change of use or something like that, where they responded that it should be denied because they were trying to go through undue hardship stuff with this, and that went through some iterations. But anyways, at that point, their response, I believe, was to say, don't allow it because the property still has value just for the fact that you could put a bench on it and overlook the water.
Yeah, that sounds like something they would say.
Okay.
Yeah.
And it absolutely has nothing to do with resale value, right?
That's exactly right. Yeah, in fact, so the other sort of closest thing we have to a definition is from another case in Fayette. The court said a reasonable return is not the maximum return for purposes of the reasonable return prong, meaning because some people, and I remember this when I was on the Board of Appeals myself, would argue that they needed the variance to have a reasonable return from their perspective, right? But they could have had a slightly smaller house or a slightly smaller bathroom addition, in a specific example I can think of. They just wanted that one. And in that case, you know, they didn't meet that standard because they could still do something. It just wasn't what they wanted. But so that's another example.
Can I ask a concrete
Yeah.
example just to help
Yeah.
clarify this? Let's say that there was an ordinance change in between the purchase. So somebody purchases a lot.
Yeah.
There's an ordinance change that drastically reduces the the value of the lot, and that doesn't fall under a reasonable return on the land. So like if let's say in May I buy something, in July there's an ordinance change, and I come and say like, look, my reasonable return is not there anymore.
Yeah.
You're saying that does not meet that requirement.
Well, if it did take away all reasonable return, if that
Well,
changed,
yeah, but okay. But if
Yeah,
the
it's like
substantial value of the property was for like a single family dwelling that could no longer be put there,
that's right. That
then
likely
you could
would
still
not
put a
meet
bench
that.
or use,
Yeah.
you know, access to the water.
There could be other things you could do with it.
Gotcha.
Potentially. Again, it depends on the circumstances.
Gotcha.
Maybe there's not in that circumstance, and that applicant would try to argue vigorously with you that there's nothing else they can do.
Understood. Yeah.
And some people are successful with that with boards of appeals.
Well,
So
how do you suggest similar follow-up to that?
Yeah.
Because we hear this one all the time too. Assessed value. You know, obviously, assessing might say a lot by the water's worth 60,000, but
Right.
you know, realistically, and they've been paying taxes on it for 30 years or whatever, and they can't build on it, which they have an opinion that if a non-buildable lot or unbuildable lot isn't worth 60,000. How do you suggest these guys combat that when someone's putting, you know, a town's tax card up saying it's worth 60 on my tax bill, but you're telling me I can't do anything with it? Is there?
I say we'll take it up with the assessor.
Yeah. So ignore
That's not your jurisdiction.
Right.
Yeah.
ignore assessing information.
That's
They
right.
can always apply for an
An
assessment.
abatement. Yep.
or
Yep.
Reevaluation.
Reevaluation or yep. That's
But that
exactly-
reevaluation would have to go to 0 for that to qualify, essentially.
And it never will.
It never
So
will,
I'm just stuck on this because all value of the property is never gonna go to 0.
Well, it's a
So
use issue,
You could go
really.
look at it.
It's a
Just say,
use
I like
issue.
the bird watch,
Right.
and I could say hypothetically. I'm not trying to be combative. I just like trying to put myself on the other side when
Yeah,
we're,
no, it's
when we're
difficult.
oftentimes,
It's the hardest
you know,
part.
It's the hardest part. It's very frustrating. So the reason why, and you may want to consider this in the future, some towns have even added it recently, there is the optional variance. It's called a practical difficulty variance. It does not include that standard. That's what makes it quote unquote slightly easier. It still has a financial component to it, and I didn't bring it, so I don't want to cite it. I don't want to read it off the top of my head, but it doesn't have the maximum, it doesn't have the reasonable return standard. And that was added, I think, in the 80s, partly in response to the fact that people were frustrated that there was no way to get variance, or it was very difficult. I shouldn't say no way, granted, but it was very difficult to get them. And so you could put that in your ordinance, and people could try to apply under that standard.
that's something when you
And
say
that uses something called financial difficulty.
Okay.
It's a slightly different standard. So that would have to be put in by the town meeting. It would have to be an amendment to the ordinance,
okay.
but that's just an option.
So if anybody out there is listening, there is an avenue.
Yeah.
It's not, we can't
Still
change
difficult.
it. We can't change it.
Not gonna say it's not difficult, but
Yeah.
but it's a slightly easier to
Sure.
Obtain type of variance. So the other example I had actually was the one in Scarborough. So I already talked about the other example. Any other questions about reasonable return? Again, all of these are going to be what I call fact-based. So you're going to have to look at each application, and everyone's going to be different. It's not always a no. I mean, there are ways that people can get these, and people get them. So the other one was that there are unique circumstances, and we don't actually have a lot of. We actually don't have a lot from the courts on this one. But we have some case law. We have some lower cases. But essentially, if all the lots in that neighborhood are the exact same, like they're all rocky, they all have cliffs on them, that's not unique, right? But if there's a particular property that is different for whatever reason, it's the only swampy, rocky lot, the only one with a bunch of utility easements that cross it, and so that's what you're going to look at to see how it's unique. That can be met. That standard can be met more frequently, in my experience. Action taken by the applicant or a prior owner. So in other words, you can't get a variance the short way of looking at this is you can't get a variance to fix something you did in violation of the ordinance. So if you go and build something, for example, or you created a non-conforming lot illegally, and then you ask for a variance, that would be an example of how you couldn't meet that standard. But what the courts have said is, if you buy a piece of property knowing that it needs a variance, that still does qualify. In other words, because variances are a right that you have to apply for, you can meet the standard. You weren't the one who created the variance. You were aware of it, took a gamble on it, and bought it anyway, or came to the board anyway and asked for it. So that's the one case that I really know of actually that dealt with that standard, because it used to be the opposite. That rule was flipped by the Maine Supreme Court in the 1990s. It used to be that if you knew about the problem, that actually would also disqualify you. And the court said, no, that doesn't make any sense. And they flipped their reasoning in the 90s. If you know about a problem with a lot, you buy it anyway, you can still ask for a variance.
What if they're just ignorant people that buy a lot, not even researching the ordinances?
That's still qualifies. You could still trigger. You could still satisfy this because they weren't the ones who created the problem. That's what you're looking at. Mm-hmm. And what the court said, you didn't create the problem by buying it. Someone else created the problem by selling the lot with the area dimensions it had, or whatever.
Can you just rinse that condition by selling it and rebuying it?
I would say no.
Okay.
Yeah.
Just curious.
I mean, you'd probably see through that, right? I mean,
Not that I anticipate that.
because it's the applicant or a prior owner is what the standard says.
Okay.
Yeah.
Okay.
So,
Or sell
so
it,
you would
have
then
them
be
get the
the
variance
applicant
and
and
then
the
buy
prior
it.
owner. Yeah, you would be both. And then the final one is that the granting of a variance will not change the essential character of the locality. That's an interesting one, and I want to take a moment because in my notes I've done before, I have nothing on that. But we now have something from just a couple months ago for the first time. A July case, Hill versus the Town of Wells. And the court gave us a definition, or helped us with the definition on that for the first time. And that was a case in Wells, again, also Wells has a bunch of wetlands along their waterfronts down there. The property owner asked for a couple different variances to allow him to build a fairly big house on a very small buildable envelope. And in that case, the board denied the variance, partly because of, and the only thing this case deals with is they're actually dealing with the essential characteristics requirement. So I don't know if he also found a way to meet the reasonable return or not. It just doesn't deal with it. The issue on appeal was the essential characteristics of the neighborhood standard. And what the court said is, it's interesting. First, they went into a fairly long set of discussions about all, and particularly in that area, the environmental rules and areas that sort of govern the wetlands there. There was that particular property was within a wildlife Drake's Island game sanctuary, that it was which had various rules around it, that it was part of NERPA, which governs wetlands. It was next to the Rachel Carson National Wildlife Refuge. It went through a long series of things on why that was very important to them. It was also in the shoreline zone, which is a set of rules that govern that area. All these rules about setbacks and stuff were there for a reason, essentially, is what the court said. And then they said three things. The meaning of the essential characteristic of locality, first, is informed by its context within the variance criteria, and it is context dependent and not limited to developed uses and values. So, in other words, in this case, it was context dependent in the sense that it was in this undeveloped refuge and wetlands. But that was important in this particular case. And it's not just economic terms, it's environmental terms too. That's, the court specifically said that. Impact is measured not only in economic terms, but in the effect on environmental values. So you're going to look at those things. But then I also thought this was probably the most interesting, is that the variance must be compatible with the district as zoned, not just the surrounding non-conforming uses and dimensions. So in that case, there were a bunch of houses that were built in the wetlands, it was along the waterfront there. And the applicant argued this is not, in fact, different, right? That it's not going to use the exact language, alter the essential character of locality, because there's a bunch of houses sort of like what I want to build all around me. But they were all non-conforming houses for the most part, either legally non-conforming or they all were legally non-conforming, but it's because they're grandfathered or because they may have got a variance on their own in some past year. And what the court said, that's actually not what you look at. You look at what's supposed to be zoned there. And that's different. That was different. I would have said beforehand, no, you do get to look at the surrounding area when you're looking at the context of the locality. And the court said no, because again, the purpose of zoning is to reduce nonconformities. And if we look at it that way, you could just continue to be more and more nonconforming throughout town as you expand and look at all your other nonconforming properties around you.
Right.
So that's one thing you're going to keep in mind if someone's trying to argue it's not going to alter the locality. Is to say, but what are you comparing yourself to when you're saying it's similar to those things? So that's a relatively new case. We're all kind of just still sort of digesting on that standard.
This might be, I have a question that I think is related
Yeah.
to this particular thing you're stating, so maybe it's a good time to address it.
Sure.
But, oftentimes we will be on a site walk, or somebody will be, kind of giving their opinion on something, and they'll reference some previous action that the previous board has taken,
Yeah.
as if that's somehow supporting a decision that we should make. Do we just ignore, like, what utility is that? Because
It has very little utility
Okay.
to me. You don't have precedent, unlike a court. So courts
Okay.
do have precedent, and they have to apply the law as they applied it in the past. That's the way our court system works.
okay,
Is that are not one-off cases like that. You are one-off cases.
okay,
There's no precedent. You're looking at an application. So application stands on its own,
Yeah.
essentially.
okay,
And every application has different facts, and you're applying the facts to the ordinance as that. Now, should you sort of try to be internally consistent as for yourself? Probably,
right,
but you're not required to even. So there's certainly no board precedent, but the way I always looked at it when I served as a board, but you want to kind of be consistent with the way you're viewing the ordinance as an individual board member, right? Because that provides some stability in the way people know how to apply to them.
yeah.
If
So
that
the old,
helps.
like, my neighbor put a garage close to the road, I should be able to put a garage close to the road.
Right, like that has no
It's
bearing
not-
on it.
It's just not considered.
It's not, right,
Okay.
it's did they meet the standard in the ordinance? Keep coming back to that,
Yep,
and maybe they don't.
I got
Yeah,
question as
Yeah.
well with the hardship. And this goes back to that one which started down the path of variance with undue hardship, and then it shifted over to something else. But they wanted to have side setback reduction in order to build basically a staircase.
yeah,
But it was acknowledged that they could still build the staircase without the setback, but it would just cost them a lot more money and a lot more effort
yeah.
to do it. So they acknowledged that they could do it, but it would be easier and less expensive to do it with the variance. How does that fit in?
Well, it does fit in because I think, yeah, that's in the limited reduction of yard size residential, which is what you're talking about, right? It was a side setback, it was the
Yep.
residential side setback, which is a
Yeah.
different type of variance.
Yep.
But one of those criteria, and actually some of them are similar, so unique
I
circumstances of the
jumped ahead on
neighborhood.
that.
That's okay, because I was done with undue hardship in this sort of question. There are 5 standards for that, and some of them are the same. So unique circumstance of the property, not general conditions of the neighborhood, will not alter the essential character of the locality, was not a result of action taken by the applicant or prior owner. And then these are the 2 different ones. So we've already talked about those 3 in a different context. The granting of the variance will not substantially reduce or impair the use of abutting properties. So that's the effect it's going to have on neighbors. And then this is where I think your question gets to. And then finally, that the granting of variance is based on demonstrated need, not convenience.
Yeah.
And no other feasible alternative is available.
Yeah, that's it exactly. Because
Yeah.
before it switched over, I
Yeah.
was humming and hawing in my head. What does feasible mean?
Right. And there's not a lot of guidance there. That's actually one of that language is used in that other practical difficulty variance I told you about. So that's the other place you see that language. But feasible is a little bit in the eye of the beholder, and that's where there is some discretion you guys have in how you think about things, right? Like what's feasible to one person might not be feasible to someone else, quite frankly. An obvious example is like someone with a disability. Like you might be able to build something, and now I'm talking about disability variance, I'm talking about even under this standard, right? Like it's not feasible for someone to actually use a staircase over here, just the way, because of a disability, for example. That wouldn't be feasible to them, but it might be feasible to me. So it's going to be based on the circumstances of the application. I'd say similarly, economics can come into play there, right? Like if it's just you could do something, but it's wildly expensive, that it wouldn't be feasible to the average person. I think that would be a reason to find that they wouldn't have another feasible alternative. If it's within a couple $1,000s, well, that might be a different question for you, right? Which is that they could build something within the ordinance requirements for a little bit more, then they have a feasible alternative. They just don't want to spend that extra.
In this case, we don't granted a handful of feet, and it's both the budding where they're in like 4-acre lots.
Yeah.
You can't even see the other house.
Right.
So,
Right. Right. And there's some,
let's try and be reasonable.
There's some of that you're going to be playing in this role, right? You do your best to apply the ordinance, but again, the way I always look at it is every application is a little different. You may give you reasons why you come to a conclusion on one and not the other based on the circumstances of the property. As long as you tie it back to the ordinance standards, that's the important thing. So the only other thing I'll say about setback variances is that they're limited. And this is in the statute and it's in your ordinance, but it can only be up to 20% of the setback. And that's partly because it is a little bit easier, so there's a limit on how much you can go. If someone needs the 30%, now you're back into the undue hardship variance.
I have a question. Can you explain why the wording is different in shoreland versus the land use? One says something about for a single family dwelling that is the primary year-round residence of the applicant.
Yeah.
And shoreland says slightly different criteria.
Shoreline
Sure.
has
Sure.
the undue hardship, and then it also has I think regular has undue hardship or undue hardship stuff for single-family residential.
I'm at an undue hardship. I'm in the setback.
It's in the setback.
The other, the shoreland says setback reduction appeals may only be granted and are only available for lots with a residential dwelling as the principal structure.
I think that
They're
was
slightly
amended, though,
different.
right?
Was amended.
That was amended
Yeah,
to be.
existing, right?
Yeah.
It says existing now.
Yeah, that's right.
But still, the
It should be
words
the
in
same.
One says it's got to be a year-round residence and it's got to be the primary whatever, and like, why is?
I don't know if I captured the amendments. I know they're not on a different link, but yeah, the other difference is that there's a couple more criteria.
There was some history to it, I just can't remember what the reasoning was.
Yeah.
You
Well, it
didn't
should be, I mean, because it comes from the statute, there's not a separate shoreland variance. There's the DEP puts their chapter 1000, they call it, that's the model shoreland zoning ordinance, but for the variance provisions, they take it from that Board of Appeals statute that I mentioned.
Well, they're slightly different, just, you know.
Yeah.
If we say, hey, oh, sorry, you don't qualify because it's not your primary year-round residence, see ya.
Yeah, and that primary year-round residence comes from the state law that authorizes you to put this type of variance in your ordinance. So that is a requirement, and it's in your land use ordinance,
Yeah,
right?
but the shoreland doesn't say that.
Right. Well, we can take a look at that. Yeah.
Is it-
Alex and I can take a look at that. But what I always say in that case is that we sometimes come across, and I'm not saying it's the case that this is somehow illegal or not consistent, but you have to apply the ordinance as written, even if you think it should be saying something different. And we get that question like almost daily. There's some potential problem with an ordinance, and what I would say is you have to apply it until a court or tells you not to, or the town meeting amends it. What we like to do is, when I'm working with code officers, we keep a list, or we start putting a list together for the next town meeting to say where some cleanup needs to happen. So maybe that's an example. So we'll take a look at it and see if maybe we need to tweak it a bit more. I know it was just tweaked last year a little bit.
Yeah. Can I ask you
Yeah,
another
absolutely,
question?
anytime,
about-
yeah.
So, at the very beginning of this, you said it's sort of like the burden of the applicant to give
Yes.
us the information we need.
Yeah,
So let's just say there's something like this undue hardship.
yeah,
And we believe there's undue hardship, but they haven't presented the information that we think they should have presented. But we're seeing something that perhaps they missed, right?
Yeah.
So do we bring it up and kind of coach, I don't want to say coach them through it, but bring up some things that we've noticed to potentially everybody consider, even though they as the applicant haven't presented it to us?
I think you can do that.
Okay.
Yeah, no, I've always thought you can do that. And you
I
can also even
assume-
ask for more information. And that comes, I mean, there's a reasonable amount of time. You don't want to allow someone to come back to you 3 times, 3 different meetings, right? But I think it's entirely reasonable for you to say, for example, it's not that they don't meet it, but they didn't give you enough information to base your decision on, and that they should come back, and you could maybe table it for 1 meeting, and give an opportunity to, supplement their application. I don't see any reason why you can't do that. Again, you shouldn't be doing that forever. You've got to make a decision within a period of time.
And I just didn't know if it made it look like we are trying to allow something to happen.
Right, like you're bringing your own.
Yeah,
Yeah, no, I mean, I think it's your interpretation is what
Okay.
you're getting at. If it's based on information that no one else has, that's a different story. Like you've researched it and you found something and like, look, I found something that will help you. You shouldn't be doing that. But if you're looking at the materials they gave you and you say, look, I actually, in my view, this does meet the standard for these reasons, that's entirely within your purview to do.
okay.
Yeah,
Or even if we see something else in the ordinances that's like, oh,
yep,
perhaps this applies or.
right, that's right.
That's all,
Yep,
okay.
certainly can help them. And that's also partly the job of the code officers. When they first come in, the code officer often help them try to figure out where it best fits for them, what they should be applying for, essentially. It's not a gotcha kind of thing. It's like, we'll help you. It doesn't mean you'll necessarily meet the standard, but we'll try to get you to where you need to be in terms of applying for things.
Okay.
So you have 2 other sort of, 2 other areas that you apply. You have something, conditional use permits. Those are fairly straightforward. And again, that's something that the Board of Appeals law allows you to do. More and more frequently, we see those being moved over to the planning board. In Raymond, it's still under your jurisdiction. The statute allows towns to decide if they want their planning boards to grant those instead. And the only reason why is because usually conditional uses also require site plan review. So it's a way to, not have an applicant, honestly, it's more efficient for an applicant and potentially for the town to have everything right in front of the same board that's going to review it anyway in more detail. So that's a policy decision for the town, but currently an applicant would need to come before both boards. And so what you do in that situation is you just apply the conditional use standards in the ordinance to the application. That's more straightforward. And the only other thing I'll say about that is conditional uses are allowed uses. So it's not that, that's the thing to remember. It's just that they're allowed uses that have conditions that someone has to meet instead of as of right. And I think that is it I wanted to talk about. So when you're making your decision, and we've gone over a number of different things in terms of the way a meeting is run, in terms of allowing testimony and things like that. But the only other thing I'd say is what's very important is your findings of fact. And I don't know if do you help as staff prepare those? Their decision forms or
David's
something?
been doing them.
Okay,
He's pretty good at it.
good.
Yeah, he's done well. I mean, we look
Yeah.
at them and,
Yeah.
if
I
there's
think that-
anything
Good.
that's like blatantly missing, we would point that out.
What's typical? Is it typical for the board to do it, or is it typical for somebody on the staff to do it? I'm curious.
It's,
As somebody who might be and writing them at some point.
yeah, it really depends on the town, I'd say. Well, I mean, because I work with towns that run the gamut of like a full professional staff of 6 or 7 people in that
Right,
office,
right.
who almost always write them for the boards, to small towns who don't have any staff.
What's typical
It's
for a
completely
town the size
volunteered.
of the town?
I think it's
town of
typical to
Raymond?
have the staff assist in some way, whether it's reviewing it like you do now or the first draft
Okay.
after the meeting. But if you have someone who can do it, that's fine.
David, I'm not. He does do a great job, so
Yeah.
not to.
Yeah. So the key there is, and I don't know if you have a form in front of you, but I like to have a form. You know,
Like, there was a lady, I wish I could remember her name, she was on this board before and she
Yeah.
had written up some of the past, so I've taken hers as a guideline to
Yeah.
develop.
Yeah, so like, the undue hardship, for example, there's 4 criteria. I always felt it helpful to have the form right in front of you with those 4 criteria.
Exactly.
It's a checklist, and it also reminds you need to have findings under each one.
Yep.
Conditional uses have a few more. You know, you could have a standard conditional use form. Some uses have additional beyond the standard, but the important thing is, and I can't emphasize it more than anything, the thing that gets decisions overturned the most is insufficient findings of fact, by far. It's not that you've misapplied one of these standards like we've been talking about. It's not conflict of interest. It's that there was insufficient findings in the record. The courts have no patience for it. I think they used to have more patience, I've been told, from some of my colleagues who have now retired. But when they were teaching me, they said, courts have changed, and I can tell you since I've been practicing about 20 years now, I can't tell you how many, you feel like you've gone through a year and a half, you've got everything done, and the court takes a look at it and says, not enough in the record. And what they'll do is they send it back, so it gets remanded and you're starting the whole process over again. Well, I shouldn't say over again. You're having to just do the findings, actually, interestingly enough. When it's remanded, that means they're not actually disturbing your decision. They're just saying, now you need to fill in the blanks of what you did, so then court can see if it's supported by substantial evidence in the record, which is the standard they're going to review it under. So it's important just to make sure that under each standard, even a sentence helps. But if you have a little bit more, how did you make your decision? What did you tie it to? Why didn't it meet it? Why did it meet it? Put it right in there. If you have even a little bit and it's tied to something in the record, that's likely going to be sufficient. But it's the boards that just write approved, and that happens, or denied, right? You'll see that from time to time, and that's completely insufficient in the court's view. And you'll get it back here in a second. And in fact, if I get a case, appeal comes in, and I get the complaint, and I haven't been involved, and the first thing I do is have the town send me the decision form, findings of fact, and if it looks insufficient to me, I've been known to work with the plaintiff's attorney right off the bat and having a voluntary remand. Once they file with the court, we have to actually have a court remand it, but you can file a consented to remand, just because it'll save everyone time and money to not have to brief it, argue it, sit months on the docket, and then have the court do it anyway. So that's the first thing I'll do sometimes. If there's no written findings, I'll just say, let's just both agree to send it back right now before we go too far down the road, have the board have a meeting and fill in the blanks, essentially. But it sounds like you're doing that. Good job, but I always have to say that
I
because
don't know if
that's
it's
the
a
one
good job,
thing.
but we're doing it.
Yes.
I'm putting at least one sentence with.
Okay, well, that's the
each
one area
so.
where boards trip up frequently. And it can be difficult, honestly. It can be difficult to do them. I'd say a little bit less so for boards of appeals, not that you have a hard job. Planning boards typically will have 20, 30 standards, right? A lot of times more factual in nature, quite frankly, but there's just more of it. And if you don't have a forum, it's easy to say, I'm not get through everything, but it'll likely get remanded.
I do have a specific question
Yep.
about the finding of facts.
Yeah.
Is there anything preventing us from electronically signing them? I know Sandy's trying to corral us and to come in and physically sign them. And at the end of the process, the applicant, if it's approved, is sitting there kind of wondering, where's the...
No, I don't think there is. I mean, it's a lot of it was specifically allowed during the executive orders that were in place. Those have all been repealed. But I know that a lot of, we were even allowed to sign documents for the court now electronically. So there's no prohibition against it. It's like you would just have a policy. The one thing, if you really get into the weeds on that issue, the issue is you want to protect against people forging them.
Yeah.
So there is a whole area of law about, you have authentication. That's why you use the DocuSign program and things like that, because they don't want, you have to prove that someone actually signed it. It wasn't just, But there is no prohibition on electronic signatures.
Is that a policy we could adopt as a board right now?
I think you could. I mean, you may want to think about it together as the town as a whole, and if the select board has a policy on that kind of thing. But
Yeah, we'll have to go up the ladder on that one.
I'll tell you the other thing that boards do if it's a pain to get everyone. You don't have to have everyone sign it.
Okay.
You can just have the chair sign it.
Okay.
And that will often have it too. Is that you vote to your policy is the chair signs on behalf of the whole board. There's nothing that says every board member has to sign. Every board has to vote, so you know that it passes,
Sure.
right?
Yeah.
But you don't all have to sign it.
Yeah. I just feel bad for Sandy, trying to
Yeah, but
Track
I'm good at nagging.
track down everybody.
You still have to sign this.
Admittedly, I've been delinquent once or twice here, so.
I had
think,
an excuse. I was multiple states.
Yeah, some
away,
people are just,
so-
yeah, I mean, now that we're doing the video stuff and, you know,
Yeah.
it just seems more efficient, so
yeah,
whatever we can do, I don't know.
yeah. Well, maybe we can talk about that in terms of as a town itself, how to electronically sign it, but.
Okay.
I think that's all I really had. So besides the court, the last thing I want to say about findings of fact, besides the court saying that they're required, the Freedom of Access Act itself actually has a provision that says any conditional approval or denial of any board in the state has to be in writing. It's funny, it doesn't just say approvals. It says a conditional approval or denial. The idea behind that is that people have to have the right to decide whether they agree or not with your decision in writing so they can decide whether to appeal. I usually expand that to say every decision. It just makes much more sense, and we've already have the courts telling us that we need that for them to conduct meaningful judicial review of determination. The only other thing I was going to just mention briefly is finally just standing. That comes up sometimes. People ask if they have standing to bring an appeal. And in fact, I just dealt with that with the board last week, where there was an argument that someone didn't have standing to bring an appeal when they didn't like a permit, for example, that was approved. Standing is something, it's one of the, we call them threshold issues. So you have to be able to bring an application before a board. You have to have a couple different things. One is standing. One is, if you're an applicant, it's right, title, or interest. So you have to have a right of property ownership of some kind. And then also the other jurisdictional issue for board is, does the board have jurisdiction to be hearing this application, right? Very easy, just almost laughable example. Someone brings a site plan application to you. You don't have jurisdiction to review site plan applications, and so you deny it, if it even got to you. But if it did, someone applied to you for site plan approval, you said, we don't have jurisdiction. We literally do not have the authority to grant this, so it's denied. That's why I went over your jurisdiction earlier. You know, appeals from the code officer, variances, that kind of thing. That's what you're allowed to, that's the only things you're allowed to do. For standing, and this comes up because not everyone can appeal a decision. For example, if there's a property owner gets a building permit and someone 5 miles away appeals it because they don't like it, they probably don't have standing to bring that appeal. Your ordinance doesn't have much to say about it, but but the courts do have a test for it. Typically what we do if it's in an ordinance, it's whoever was able to have notice. So for your hearing, sometimes it's 500, everyone within 500 feet or 1,000 feet. We usually say that's a shorthand for, well, those people have standing to bring the permit, to bring an appeal. Immediate butters almost certainly have standing to bring appeals. But what the courts have said is there's two things you need to have standing when you get to the court level. So it's something we look at here. One is you have to have particularized injury. That's where we use the shorthand for 500 feet, 1,000 feet, meaning it's not just the community as a whole doesn't like it, it's that something might affect you. They call it particularized injury. It's something different. You're going to be affected in a way that's different from the general public. So direct abutters, you likely meet that test. We have a case that said drive-by viewing is not enough. So someone in one case appealed something and they drove by it every day to work and they didn't like it. They didn't like the look at it. And the court actually said, we do not have drive-by standing in the state. You have to have particularized injury, not just the general member of the public, to be able to appeal something. And then two, and this is you have to have actually participated in the proceedings. So that applies if someone's applying to court. So someone can't appeal your decision, for example, if they didn't participate in the underlying proceeding. They didn't come up, they didn't show up and comment, for example. You lose your right to appeal your decision if someone doesn't participate. So you have to meet those two standards.
Both.
Yeah.
Not just
When you get to
one or the
court,
other.
you have to meet both. You have to have, this is to get to court. You have less of the participation of the proceedings because you are the proceeding, right? If it's when it was the planning board, when you used to have some jurisdiction over planning board decisions, that's where you would apply that. So if the planning board approved a site plan or review and then it was appealed to this board, a member of the public who didn't participate in that planning board hearing could not bring an appeal. They wouldn't have standing to do so. You have to have participated. That's one of the requirements.
So when we notify people, it's
Yeah.
public notice and then immediate abutters or
Yeah.
whatever.
300 feet.
300
But
feet.
what if, it's part of a homeowners association and only the immediate abutters got notified and people in the homeowners association don't agree with what got decided? Is that legal or not?
They may not have standing, so they're gonna have to meet that test. What they can do is anyone in the public can come to, like, say it's for a
Yeah.
variance, right?
But maybe they didn't know about it and they don't read the public notice.
Yep. So it would be, if the town complied with its notice requirements, that would be sufficient.
Okay.
So it's not that they didn't, so in other words, they're expected to know about it. If, for example, I don't know if you put it in the paper anymore.
Yeah, we do.
So if it was in the paper, it was on the website, probably. It went to the abutters. And sometimes even literally tacked to somewhere sometimes. That's enough. It's
Yeah.
enough. Yep.
Let's check them.
Yep.
Tom, you want to ask the question you had at that last meeting about right title or interest, with it being dual ownership or someone,
Yeah.
it was brother and sister?
Yeah. So we had an applicant, and it was husband and wife that filled out the form. But in the paperwork they supplied was a plot plan from a survey from 15 years ago and so on. And in her write-up, she said joint ownership with brother, but they were never on the application. There was nothing in writing from the brother that agreed with the application. So I kind of questioned, do you own it outright now 100%? And was there some deal along the way? That
Yeah.
and she claimed that, no, there was still 50-50 ownership. And I was like, how do we know that your brother agrees with this situation?
Well, that's a very good question. I didn't get into right title and interest very much, but this is what the courts have told us, is that we're not a title court, right? So we're not going to decide disputes of title and that sort of thing. That's for the courts to decide. But we have a threshold that someone needs to provide, which is that they have sufficient authority to use the property in the way that they're applying before the board to use it. That's it. That can come in the form of a deed, and I'll get to your specific question in a second. A deed, even a contract, a purchase and sale agreement, that qualifies. In fact, you typically just see purchase and sale agreements for very large projects that you might hear about, where multi-million-dollar projects, because a developer's not going to buy it unless they get their approvals. So sometimes that's all the developer has is a purchase and sale agreement. Option contracts, that qualifies. Leases qualify sometimes with permission of the owner, things like that. Future tenants, that kind of thing, with some sort of agreement. So all that kind of qualifies. It's a pretty low bar, but you have to have something that shows you have the right to do it. Now, joint ownership, I would say I would not probably look beyond that, because again, we don't have the authority to look at a deed and determine who has the ability to do what. If you got a letter from the other owner,
That's kind of all I was looking for.
then it would be something for you to note.
Thing that he signed that says, yeah, I'm in agreement with going ahead and building a house.
But I would say, what I would say is it's not required, and because they are on the deed and they have the right to use the property. It may create a private issue for that person, but that's not our purview, right? So that's what we always say. We say that a lot with covenants, like homeowners covenants and things like that. The town has neither the authority nor the jurisdiction, for example, to enforce covenants in a deed or homeowner documents. The town's not a party to anything like that. So we just want to see, do you have the right to use it? If you have other restrictions on it, that's going to be a problem they're going to have to overcome. They're going to have a secondary issue. We just are applying our own ordinances. So I'd say at the end of the day, it's probably okay. Where it's not okay is if there's something in the deed that you can't overlook, right? So they give you the deed and it says, and this is actually something that happened over in Casco somewhat recently. The court had the opportunity to review this issue, and it was about using the use of an easement to get to a piece of property. It's called Thomasino versus the Town of Casco.
We know about that one, don't we?
Yeah.
And it's caused a lot of
My bad.
correspondence.
I started that one.
Oh, you did? Oh, I didn't know that. It's become a famous case now.
Oh, I know. Yes, he started that.
So what I quoted to you because I say it so often. So it's like the black letter law is we have not the authority nor the jurisdiction to interpret private deeds and covenants. We just don't do it as a town, and the courts have told us we can't do it. So we just do that threshold review. You showed me enough, right? If there's a fight about it, you guys are gonna have to fight about that on the side with the court. This case kind of changed the presumption a little bit, partly because of the way the board ruled, quite frankly. There was a debate about whether the property owner had the right to clear trees to use this easement in a way under their easement, and they wanted to clear trees to get to this piece of property. And I think the board found that they did not have right, title, and interest because in their view, there was a sufficient question on whether they could use that easement in a way that the property owner was asking to use it. And that's unusual for a board to wade into that, but that board did wade into it and say, nope, under our reading of this easement, you either don't have the authority to do it, or we don't have enough information. And in that case, there wasn't a butter who was the easement the underlying owner of that easement was an opponent. So it was, they both had strong views. And the court actually upheld that and said, if there's a private dispute over a piece of property in a way that a board can't make that kind of even threshold discussion, then they need to go get it resolved before a court first, and then come back to you to show that they have sufficient right, title, interest. So in your example, if you had a deed that showed two different owners, and there was some question even in the language of the deed about what they could do, and you had the brother write to you and say, she doesn't have a right to do this, and I disagree with it, and it was at all a colorable argument, you'd probably have to say, well, under this new Thomasino case, you should gotta go to a court and get your rights figured out and come back to us. It really changed the presumption, and it gives opponents of projects a lot more power. That's the way I review that case, to slow down a project or to stop a project by disputing the title and the underlying title.
And you brought up the easements. I read something just recently where people that have a right of way to the lake, let's say.
Yeah.
It's changed at some point in the last 30, 40 years. They don't have the right to build a dock at the end of the water access. And I know there's, I think, a still ongoing court case in my neighborhood for that subject.
I've seen that, yeah. There's a couple different cases going on around the state, but we might get some guidance from the courts on that within the next year or so.
And I guess it's been
that,
going on for a couple of years in
yeah.
the courts.
Yep, yes, yep.
So,
Yeah, I'm aware of that issue too.
oh, okay. Sorry, it's not me.
Yeah.
But,
Yeah.
But yeah, they argued, but they don't have the right of way written in their deed or something.
Right.
And we're like, I won't name names and
Right.
whatever.
No, but I'm aware of that. But that's the kind of thing that under this Casco case, that if there was an argument, someone's coming for permission for something for you or from the planning board, and there was some argument that that the easement didn't give them the right to do what they're asking to do. It does, in my view, the reason why I was not a fan of that case as a municipal lawyer is it does require municipal officials to kind of look underneath the deed a little bit more in a way that I don't think we have the capacity to do and we shouldn't be doing. But the court has said this. We'll see how much application. There's been a lot of debate in the municipal community about it, about whether it'll be kind of limited to that set of facts in that Casco case, and maybe it's not going to be a big sea change like I'm nervous about. And there's a chance that it might be limited in the future, but just that standing on its own has a lot of impact, I think. So.
I did have a couple of pointed
Yeah.
questions that should only take one might be a yes or no answer,
Sure.
but it's with respect to the burden of proof that it's on the applicant.
It's on the applicant, yeah.
Yeah, and my question is like things like, I took some notes, like the primary residence, being year-round primary residence is
Yeah.
part of some of these decisions we make, and like the feasibility or cost differential of staircases and whatnot, and this comes up from time to time of like, it's oftentimes somebody just telling us like, yes, I'm a primary resident, or yes, it's not feasible for me to build stairs, or this project doesn't or does do this.
Yeah.
Is it, so like take primary residence for an example, like, I feel like most applicants are not equipped to basically demonstrate that to a like really, really strong degree of proof. Are they under any oath, or is there perjury if they lie or anything like that? Because that would kind of take care of that. Or like,
Yeah.
it seems inefficient to, have somebody show us that they've been there year round, because no one has come and provided.
So people are not under oath here, but your decision, if you use their testimony is evidence.
Okay.
By the way, it's may not as good. You weigh testimony on its value, but it is evidence. You can rely on testimony to the extent you think it's reliable. But if it ends up that someone's telling you something incorrect, or you could try to revoke the permit in the future, or there could be some sort of enforcement action. It's a very rare thing, but code officers, that's one of the ways you can revoke permits, is if the applicant gave incorrect information.
Okay.
It becomes harder to do that the further out you are in time. But that's one of the...
Yeah, and I'm probably not going to go around checking if people are private. Like,
Right.
it's also not effective.
Right.
So,
But
And
code
revoking a
enforcement
permit.
has a thing to put out, what, certificate of occupancy? If-
Yeah, the revoking
something,
wouldn't come
or-
from you. It'd likely come from like a building permit or certificate of occupancy, things like that, because there's no real process for you to do a revocation of a
The
permit.
dock case that
Yeah.
you're talking about, Tom, actually involves quite a bit of information on, incorrect information being submitted. That's kind of the whole case. That,
And submitted to the court?
well, that he didn't have sufficient right, title, or interest, and he said that he did when he submitted the application, apparently.
So in those situations,
Yeah.
certain permits may be revoked. There's a process for that. You still have to give people opportunity for a hearing, to provide opportunity to rebut it and things like that. But you won't see that. You won't revoke permits. That's
Right.
the only things you can do.
but somebody just comes in here,
Yeah.
applies, lies to us. We take a lot of this stuff on face value because it's just not not
Yeah.
realistic for us to validate all these nuanced things.
Right.
And then it's up to Alex or somebody to figure it out later, or
That's where it would show up.
okay,
Right.
just yeah.
Or
just,
it would show up in appeal. So like if a neighbor disagrees with it
okay.
and appeals it, they, the first thing they would do is say that, you didn't base your decision on sufficient evidence, and they could show that it was incorrect, for example.
Or
So it would be in the applicant's interest to provide as much information as they can to you,
Yeah.
so that your decision is then based on, substantial evidence.
Or in some cases, if it's building a new house.
Yeah.
They gotta go for a building permit anyways to Alex.
That's right.
And he's gotta go, this isn't what
That's right.
the variance was all about, right?
That's right.
Or so.
That's exactly right.
The neighbor can't appeal it unless they were here and speaking in opposition, is that correct?
Right. That's right.
Yeah.
Wow. You're gonna have to remember that one.
But that's, again, that's to Superior Court, and you won't be
Yeah.
dealing with that. I'll be dealing with that in defense of the town. They can appeal a building permit if they know about it. Yeah, I mean, that's the other thing you'll see sometimes is you have to apply your 30-day rule, but sometimes people don't hear about building permits because there's no notice requirements, and the courts have a good cause exceptions, and someone could try to argue they have good cause to go beyond the 30 days, but you can't apply that. So you just have to strictly apply your 30-day.
Final question, real
Yeah.
quick. And then the only feedback that we get would be from an appeal or a court or something like that. There's you're not going to come to us and say you're not, you're not interpreting the ordinances, you're being
Right.
overly. So this is really just a really long, slow feedback loop. We're not going to
Kind of,
learn
right.
about this from you, or Alex isn't going to come and say
Right.
hey, maybe you want to consider this.
So
and this and this.
where it comes up sometimes outside of a specific application is staff or the chair may realize that you may need, a primer on something.
Okay.
And sometimes I'm asked to write a letter, for example. What does this mean? What do the words of this provision mean? And I'll provide a little guidance in a letter. I've done that. Or maybe I'll come back for another specialized specific training for half an hour on something or 15 minutes on something. I've been asked to do that when sometimes boards go off the rails a little bit.
Yeah.
Never here, so that's good. That's a good thing, I guess.
Well, we appreciate your time.
Yeah,
Yeah.
thank you. No, thanks for having
I
me.
got one
Yeah.
more question.
Yeah.
So it kind of goes back to like if I'm asking Alex or Sandy for some information about something, like in the past I've had to ask for a definition of something.
Yeah.
And they provided that to me. How does that affect though the people that are doing like the appeal? Should the person who's making the appeal know that I asked for that information as well and get that response from Alex of what this? Because what I do is I at least try to read it during the meeting.
Yeah.
So they know what, but it gives them like virtually no time to digest that and potentially come up with a response to, well, I would interpret that definition as something different based on this. Like I want to be fair to them and give them
Yeah.
a chance to respond.
If there was something provided to you ahead of time, like a staff report or an email or a piece of information, then it can be included in the packet. And that's one thing I like, or the information that goes out for that meeting.
Yeah.
And so, these are the different additional information. You should do that if there was like something that you were actually given, right? Like some documents or some written materials from staff that can be shared with everybody at the same time. If it's just a conversation you had or something that sounds like more informal, then no, I don't think you need to give it that ahead of time necessarily, but you do need to talk about it that night. If it's sufficient enough that it changes their whole application and they may want to think about it, they may ask you to table it to the next meeting so they can think about it and get
Yeah.
back to you.
Okay.
Yeah. And in that case, I would probably be liberal in allowing that tabling. They felt like something new came up from the board member and they want to be able to have some time to think about, to respond.
Essentially, then you're continuing that public hearing then, right? So,
Yeah.
I mean, yeah. Okay. Okay.
Well, that's all I had, but if you guys have any other questions, keep going.
Appreciate your time.
Good. Well, thank you for having me.
Okay, well, thank you very much.
Okay.
I appreciate that.
Thanks, Phil.
Yeah, thank you.
Next item on our agenda, Code Enforcement Officer Communications.
Oh, well, I don't really have much to communicate. We are fully staffed again, finally. I think you guys know Mary moved on to a different department.
I did not.
So yeah, because when you guys got on, Mary was probably the one you were dealing with because
Yep.
Sandy came in May. So yeah, Mary is now the administrative assistant for the fire department, basically. So she's moved to a different location down at the fire department, and we now have a lady named Kirsten in our office as the admin. She started a few weeks ago, and she's been doing great. And we are now officially full steam ahead, officially staffed by 4, which is a significant increase from where we were 6 months ago. So things are going well. We're getting caught up. For the first time since July 21st, 2020, the day I started, we have no voicemails in the inbox right now.
Nice.
So as of 4 o'clock this afternoon. So we're officially caught up on phone calls. At one point 3 weeks ago, that inbox was up to like 150, I think.
Wow.
So yeah, so now we're down to 0. So that's good. We were able to get caught up on some enforcement projects. We got a pretty big one that we're working on right now, and a few other smaller ones that are kind of on the side as well. But yeah, so it's good. It's been about a little over a year of restructuring from the ground up, and we're finally setting sail, essentially. So it's good.
Excellent.
That's all I got.
Okay. So it's my understanding there's no appeals for December. So we will officially call that meeting off. Okay, do you anticipate anything for first of the year at this point?
I don't know about the one that
The one that withdrew.
Yeah,
Yeah.
I would say they may be
didn't bring
back.
anything in yet, but
Okay.
I would think we would probably see that for January.
I think so.
Because I can't imagine that they're not going to pursue it.
Yeah.
They just needed to go at it differently.
Yeah, there could possibly be an administrative appeal in January, depending on where some enforcement action goes. That's possible. But other than that, I don't know of any others right
Okay.
now.
a potential applicant for a ZBA.
Right there would be Fred.
Excellent.
So as soon as we have another meeting, we'll get him on there and
All right,
do the little interview thing and then move it to the selectmen.
sounds good. You guys have anything
As
for
long as we
Alex?
didn't scare him off tonight.
Nope.
Anything for Alex or Sandy? Okay, well, since.
Have a nice Christmas.
I was gonna
Yeah,
say,
too.
yeah, Merry Christmas, Happy New Year, everyone, and I will take a motion for adjournments.
So moved.
Second.
All in favor, raise your hand. We are out. Good night.
Great, thanks,
Thank you.